Help me, which one you want that
let's
put for
talk
inside?
about.
How much will me they pay you, Seth? Hey, God in heaven. How much did they pay you? Issue of blood, the man with the issue of blood. Eh? You say now will me menstruation, I full bed,
Right.
never Mohbad say. I pity your
With the
generation.
delay in that, I think this is what it just means. What that section of the evidence adds when it comes to legality of a child means is simply this. Under normal circumstance, that child is a product of the marriage. Under normal circumstance, within 280 days.
Exactly.
No.
They say probability.
No, normal circumstance. You need to explain normal circumstance.
Rotimi, just listen.
Explain to me what do you mean by normal circumstance.
Rotimi, just listen.
You don't know what status quo is. What do you mean by what the issue is? What circumstances? I beg, mute your mic and learn.
See, that evidence, thank you, Adedoyin, that evidence of saying presume is like you prejudge that this child is a product. And that is based on the premises that there is no challenge from anybody. So you use that as on a normal ground. If two people are divorced, any child battered between 280 days after that divorce is prejudged to be a product of that wedding. However, and that is why it's prejudged, it's not finality. However, if there comes any form of challenge, it will be looked into. What it then means is this: if there is no form of challenge, it is a product of that wedding. But if someone comes forward and now challenge,
I think I'm done at this moment. You're right.
So if someone now comes after now challenge, it can be looked into. But without any form of challenge, it is prejudged. It is preempt. It is
Aristocrats.
Yes.
Now this is it. I like your landing, okay? But let us emphasize the ending part of it. All right. Now, it is presumed to be the legal child of that marriage, of that father, of that mother, until it is refuted. True or false?
True. That is true.
They did not say until you challenge it.
That is the law gives room for us to challenge.
No. It's not
the law gives you room to challenge.
Calm down. Let us talk. You don't know it, you keep quiet, and people will talk.
And your English now will mean
wait, aristocrats, you understand where I'm coming from. We are the learning sake of everybody that is listening. Okay?
Rotimi, you are saying the same thing we are saying.
Aristocrats, go ahead.
We are all saying the same thing. Don't let us argue.
Aristocrats, for the fact. Now, aristocrats. Now you know for the fact that somebody is challenging the child. Okay, if the court has not given judgment on that particular trial, certainly
remains.
That's what I'm saying. That is what I'm saying.
Remains.
So if they are challenging the status quo
is established now. If you challenge it, you must establish it.
No, that's what I'm saying. So if you are challenging it, at the end of the day, you did not establish anything. The status quo still remains. So it's not because of your challenging it that the legitimacy will be now invalid.
No. Challenging does not mean it is invalid. You must go to it's just like suspect and a convicted person.
Exactly.
That is when
God will bless you. You don't like talking from opinion.
After the status quo is being challenged,
yes,
and now determined that the child does not belong to that marriage
by a competent court and a ruling is given.
Is that child still legitimate or illegitimate now?
Wait. Try to get it. Try to get something.
Okay, let's say it has been challenged. Listen to me, my brother, my older brother.
Yes.
If let's say the status of that child is being challenged by a competent court, and it has been determined by DNA, certified by the court, to be stated that the child does not belong to that marriage. Is that child now a legitimate or illegitimate?
Is no more legitimate since the court has proven that it is not. And he's saying the same thing. See,
he's not saying the same thing.
Wait.
I asked him the question. He's jumping that question.
Rotimi, try to get what he's saying. For the fact that you challenge a status quo does not mean the status quo is invalid. Until you prove beyond every reasonable doubt, and it is a judge, and that is a legal ruling by a court that it is right. That is when it remains so. But for example, I come and say, Rotimi, you are not Rotimi. That doesn't mean you are not Rotimi. We must go to court and fight it out. To let the court rule.
After it has been fought.
Thank you, Jerry Aristocrat.
Now that is a judgment.
He ran away from that question.
Then it is not.
He refused to answer what you just answered now. And that was the argument.
So, this has never been an argument here. Top movie just trying to manipulate everything. We have never said if the child is.
Did you hear what he said? Or did you hear what he said? Probability.
No, that's a fact.
Do you know what probability is? It's a presumption and probability. Are you not listening to his language?
Wait. If the legitimate of that child in that marriage has been contested by law in the court, and there's a ruling that this child doesn't belong to this family or to this marriage, according to DNA test, it means it's no more. But if it has not been, like example, Womi's child, it has been contested, but it has not yet been ruled or be clarified by DNA yet that Liam is not Womi's Mohbad's son. It's still Mohbad's son. Till now, the child is still Mohbad's son.
As of today, Liam is Mohbad's son. Until there is another fact tomorrow that is not. Until after the court pronounces that he is or is not. As we are concerned today, the status quo remains. He is a bona fide son of Mohbad and Wunmi. Until the court says no. So and that is why we are all waiting for the court. After the court process, the court will give the ruling and everybody will rest. Let's leave it like that. But it's always good to argue, yeah. Well, let's make it shorter.
Aristocrats, Isiba, there is another thing I want you to enlighten us again. You understand? Because when I talk, people will come with personal assumption and everything. But I like it when somebody that is knowledgeable, we put it to them in the context of the law. You can understand me now? Now, let's say, because there's this other argument I was trying to enlighten Paparino and this baby lawyer guy, because they made a statement, and according to them, they said the judge approval in settlement is considered a judicial precedent.
Before you go further, let me clarify another thing to Mr. Aristocrat again. What I was actually saying is that now Mohbad is not alive. And Wunmi said Mohbad is the father of Liam. And now Mohbad contests it and say, no, I did not agree. I was asking, did Wunmi have any birth certificate written in the name of Mohbad and signed in Liam's name? I said, if there is no document Mohbad left behind to show that he consented to the child, that this child is my child, can't that be contested in court? Mr. Aristocrat, that's my question.
Let's take it like this. By virtue of the evidence that we just finished discussing, that has given a validity to the fact that Liam is Mohbad's child. By virtue of that. Now, there are many ways to claim that someone is someone's child or not. through the DNA, through the birth certificate, through acknowledgement, that is pronouncement of the father that this is my child. Maybe when the person is alive, you have said, this is my child, and he has treated the person as his child, and the person bears his name. And there was no form of dispute while he was alive. And you can't come and say he's no more. Because the father, while alive, has claimed that the child is his or a child or not. Now, birth certificate is given when you have an international passport, marriage certificate, all those are legal tender that without anybody going to look at your DNA, going to go and bring your grandparents, go and bring it to come and acknowledge and all that, that is an evidence that you put directly, as long as it is of the state. You understand? However, like you said, things can always be challenged in court. They can be challenged in court. If, for example, Baba Mohbad came through the route to say, oh, Wumi, this Liam is not our child. And Wumi says yes. And Baba said, let me see the birth certificate. You know, he made a demand. And Wumi said, we didn't get any birth certificate while he was alive. And that can challenge it through that. But you need to have, which means the father never acknowledged it in a way legally. Or Wumi comes and say, well, wait, I'm giving you ways, so I'm not being authoritative here. I said, based on that, if such thing happened. And Wumi comes and say, while he was alive, I have a video where he said, oh, my son Liam, in whom I am well pleased. That itself can suffice to say that he has made pronouncement that the boy is his son, if that evidence is available. You understand? But when it comes to going to court to slug out issues, like I've always said, and we've always debated on this paternity of Liam here and there, I've always said this. This matter must be, once there is a dispute on a matter and it is not resolved individually, gentlemanly, if it is taken to court, the court now has the power to put finality on it. Now, let us go back to this case of, there is no precedence in this matter. The announcement of the court was as a result of an agreement from the party. This matter has not gone to trial. If the matter had gone to trial and they've argued front and back, and at the end of the day, the court now say, this is my ruling, this is my judgment, and it is accepted, that becomes a precedent because it's a ruling of the court. But in this, it was Wumi that finally say, I agree, let's do it. So the court is to go to the nitty-gritty of the matter, and the court has not, and because of what has happened, it has not even helped us to lay to rest if a grandfather has the legal right to challenge this thing, because it will still be a debate. That isn't a precedent, like you will say, oh, there is a judgment from a high court that says this, or there is a judgment that I referred to the other time that a child was born out of wedlock, and the family or the executor was saying, oh, he was born out of wedlock, but they were claiming that, oh, the mother was not married to him while he was alive, so the child does not have right to inheritance. A Supreme Court pronounced that under Nigerian Constitution, nobody can be deprived because the child never begged to be battered. But it is acknowledged that the child has been born by this man, so he has legal rights to his estate, whether the mother is married or not. And that matter has been laid to rest. That is a precedent. That is a judicial precedent. Here, pronouncement, and it is seen to be, that is a ruling, a document that explained why they arrived at that judgment. But in this of Wumi and Baba Mohbad, it was Wumi during the proceeding that I agree, let us go and do the DNA. So this has not, if there is a matter that will come up like this to court, until a court makes a proper pronouncement, then you can refer to it. Judicial precedent is like you carrying your Bible and saying from Acts of Apostles, chapter 1, verse 2, it is a laid down law that it is seen that a matter of this magnitude have been debated for earlier by a court. However, if the matter has been appealed against, we will then be looking at the finality of the court, which is possibly the last court those people went to, or through the Supreme Court, which is the higher court of the land. And that is why in legal matters, people usually use Supreme Court judgment as judicial precedent, because you can't. And a case that have lapsed when in terms of looking at the period of appeal and it was not appealed, then it is seen that a judgment has been passed. But we cannot say, it will be wrong for us to say that Wunmi accepting to do the DNA is a judicial precedent. It is not a judicial precedent. It is an agreement of the party to say, for that with the hearing, let us go and do the test anyway. It's not a judicial precedence.
Now, aristocrats, that is the point I was trying to clarify Paparino and the baby lawyer on. Because their assumption to it was that, the judgment is a legal precedent, that it constitutes legal precedent. I'm telling them that no, it doesn't. It's only binding in that current case. And remember, that particular case did not undergo trial. So how will it stand? How will it stand the legal precedent?
It did not. It's like you went to court and before it gets to trial, before you agreed.
So how is it going to be binding in other case?
See, so when they come like up case of myself and you go to police station with a fight, I will contact police. Police, we don't settle, we know they fight again. Then police not get wahala again, they carry your wahala, they go. It is not that police have sat on the matter and have resolved. Police did not resolve. You resolve it on your own.
Oh, so yeah, baby lawyer.
See like that.
Tomorrow, baby lawyer come and hear it too.
A matter like this can go to court and it will be seen as fresh because it is only the ruling of this one, of them doing the test, it is limited to this case alone. That is how they want to resolve it. But to use it as a reference for other cases, it must pass through the proceedings of the regular court where you have trial, you have everything, and you now read a ruling.
And that exactly. The court must have to pass judgment based on the trial. You get me? So in that particular essence, people calling the judgment a precedent, legal precedent, that is totally wrong because it is not binding in a future case in any judicial process, but that particular case.
Yeah, so it's only restricted to this very case for now.
Exactly.
And now the thing where they pay me for this matter with this, say, assuming this matter went to trial, it will lay to rest the right of a grandfather to demand for such thing. It will lay to rest because that will be a judicial precedent.
People will be able to understand the interpretation of the law and how they concluded that particular case scenario. If he had that ground to actually get the order to be determined by court process and all those things. Because
you would not tell the party. If we go to court, we are wasting our time. Because the judge will tell you are wasting the time of the court. Because there is a precedence on this matter,
already and that precedent must be binding. If it's a similar case.
Yeah, it will tell you refer to it. Why carry your wallet when something of that has been done?
They try to educate these people since headache don't they catch me. I try. Thank you. At least now all of them don't mute. But if I'm talking now, they'll be like, because of his Wunmi, because of the Wunmi. Listen and learn. Nobody should be ignorant of these laws.
Stop moving. How are you?
I'm all right.
Wait, please. Let me quickly. Come on, what are you saying? You are very wrong. You are very 100% wrong. What are you saying?
Aristocrats.
Wait. No. Let me ask you my question. Does Mohbad have the right to request for DNA?
I have already told you, anybody has the right to request for a DNA.
No, that is not my I didn't ask, does anybody have the right? Does Mohbad's father have the right to request for DNA?
He has the right, but to grant him, no. He doesn't have that. That is not my question. That is not,
don't explain to me. No, that is not, don't explain. Does Mohbad has the right
to request for DNA? He has the right to ask.
Oh my God.
He has the right to ask. But he doesn't have the legal ground for that DNA to be granted.
Now, just wait. Don't play games here. The Arisuka did not help you at all. You are in the same problem. No. Listen. You are wrong. You are very 100% wrong. Okay.
Shoot your shots.
Does Mohbad has a legal ground to ask for DNA or baby Leon? It's like you're not understanding the English you're using yourself.
Go ahead, Paparino.
No. Does Mohbad have the legal ground to ask for DNA or baby Leon?
Exactly. He has the ground. He has the legal right to ask.
Yes. He has a legal right to ask for the DNA, right?
As well as even me, so I have the legal right. That's not my question. You see, okay, just go on with Aristocrat. I think you like people who just listen to whatever you say. I don't want people to misunderstand me.
You are 1,000% wrong. You are 1,000% wrong.
Go ahead.
Now, does Mohbad have the right, the legal right to ask for the DNA of baby Liam?
Yes, he has.
Okay. Now, does anybody, can anybody, or do we have any judicial precedence of this case in the Nigerian history before, where a grandfather has requested the DNA of a child before in Nigeria? That's my question.
Come again.
Do we have any judicial precedent in the Federal Republic of Nigeria where a grandfather has requested for the DNA of a grandchild and it has not been granted? Do we have?
If there is any judicial precedent in this Nigeria that a grandfather has requested for a DNA and it was not granted.
Yes, do we have?
I don't know any of, and I also do not know anyone that has been granted.
No, don't worry. No, don't worry. Do we have any such situation where a grandfather has requested for a DNA for in Nigeria?
I just responded.
No, don't worry. No, if you don't explain. If you know, you just answer yes, simple. Don't explain. I don't want explanation. Do we have any case in the Federal Republic of Nigeria where the grandfather, has ever requested for the DNA of the grandchild and it has not been granted?
I don't know of any case like that.
Okay, if we don't have any case like that, then where does your argument of saying that this man cannot be granted by the court, where does that argument come from? Based on what? On your legal knowledge on what or what?
Oh yeah. Paparino, I already stated here, and I mentioned that there are 5 grounds that I know.
Oh my God! Is it judicial precedence? What are you saying now? You are very wrong. You cannot base on your ground. It's up to the court and judicial precedence.
I am not saying based on my ground.
What is this guy saying?
You understand? I am talking based on the ground of the judicial process that I know.
You are very wrong. Nobody can say Baba cannot be granted.
You are wrong. You are wrong.
You are so wrong. Nobody can say this man cannot be granted because it has never been done in Nigeria before.
Why you
acting as it's been done in this country before? You are very wrong.
Wait now.
Don't ever say that again in your life.
Now.
What are you saying? You are speaking as if we are not nuts here. You think we are dogs here?
And Aristocrat has been able to enlighten people.
That is how you find your way to deceive people.
Baba Mohbad has no legal ground to get DNA.
You cannot say so. You can't
given by any court based on the ground.
Get out.
Stop moving.
Everyone, no, just wait. Aristocrat, okay? Don't play to this guy's game. Whenever you speak with him, be as corny as anything. He's so stupid. Okay? Don't let him come make people stupid here. And some of you, I don't know when you guys speak to him, you always like to agree with him. I don't know why. Top Movie should never be agreed with. Don't agree with Top Movie unless he agree with you. Okay? He's very wrong. When he's speaking to you, you guys are agreeing on something neutral. That it would have been better or beneficial if a judicial precedence was established on this case. That is, if the court judgment was established on this case. All of us believe so. Where does his argument? He is already arguing as if he has a judicial precedence that is making him act. You know,
but the question
that this man cannot be granted.
The question he asked me was that,
but you know,
agreeing to do the DNA, is he a judicial president? And I said no. That was an agreement. But it will be good if there is a ruling on this that will put everything to rest.
We have said this thing before. We said, Alisoka, let me just make this, maybe because you're just coming. We have consent judgment, okay? And then we have court judgment. This is not new. We talked about it, that what was done in this recently is consent judgment. This is a situation whereby the courts, okay, preside on the judge, on the court uses the settlement that was made. Just please wait. Where the court uses the judgment that was made, that was settled or that was reached between two parties outside the court, outside the legal procedure. That is two party went outside the court and they have the agreement. The court ruled it. So they are binded. Exactly. They are binded. Resolution. Please wait. Please wait. A consent judgment is a judgment which the court adopts on behalf of two parties, which two parties has reached outside the court. Okay, that's a consent judgment. Why a court judgment is when two parties go into trial, they fight head to head. Okay, and then the judge decides. The judge decides upon the case. So a particular any court trial in which the courts has to decide the winner of the case, that particular case is a judicial precedence. Okay, simple.
That was what I said now.
Exactly, but the one that is consent judgment, it is when two parties, it is only limited to that two parties. Exactly.
And it's limited to that very case.
Exactly, to that very case. That's what we have been saying since. Tomorrow. There is nothing here. He's the one that is deceiving himself. He just wants to find a way in which he can make people look like they are stupid, like they don't understand, like there is anything special about whatever he's saying. I mean, it's so stupid. I don't like when people agree with him. No one should be agreeing with him. No matter what top movie, it doesn't have any sense. Nobody should ever agree with him. I will never let that happen. It's so stupid.
The question he asked
are we stupid here? Common consent judgment is making look like we don't know what is consent judgment and court judgment. There are consent judgment and we have court judgment. This case never went to trial. This is consent judgment. But what I don't want any of them to be saying, no, the father, top movie Papa, they no born and where. Make it say, Papa Mohbad no get legal grant. Okay, nobody can say it because you're not the judge. And we don't have any reference that we can use to this particular case. I didn't we have reference before, where the grandfather has requested before and is rejected. You can say like that. You can say so. But we don't have any such reference. So where's your knowledge coming from that this man doesn't have the legal grant, that it will not be granted? Where is that coming from? Nobody can say. We have to wait until we can establish one in the history of Nigeria. Simple thing that this guy doesn't know. Okay? Nobody should say so. We don't have such case. And it's simple as that. They don't get themselves educated. They go around lying that the man doesn't have the legal guy, doesn't have the legal grant. Then why did women negotiate it? If the man couldn't get granted, why did women resort to negotiation? If I was women, I would have been stubborn. I would say, no, I will never negotiate. Because this man doesn't have the legal grant. Why did he negotiate? I thought she wanted to win the case. She has a very good lawyer that understands. I don't know whether it's Falana or not Falana. You first stand for the case now. I've been now I get caught. Anyway, so let's move on from there.
Okay, all right. So can I make my submission now?
Yeah.
Mr. Paparino. All right. Yeah. Good day, everyone. I mean, actually came up for Top Movie. Top Movie, I don't think you know what you're saying. I don't really think you understand the implications of the things that you come up to say without concrete evidence. And some of the things that you say are actually disturbing to listen to you. So just to buttress what Mr. Paparino had just said, does Mr. Aloba have the right to ask for a DNA? 100% yes, he does. So the question is, when Mohbad was alive.
No, that's too close. He has the right to ask, yes, but can it be granted? Nobody knows. That's the right answer. Nobody knows.
Exactly.
There is nothing like legal grant or no legal grant. Nobody knows. There is no judicial precedence and there is no direct law. So don't play people around.
Exactly. Very, very true. So now let's move past that. And he said something that made me actually, come up to your platform this morning. And he said something. I'm not sure. I cannot really put words to words from what he said, so I don't want to, misquote him. But I'm just going to paraphrase it. So now you said that if Mohbad was alive and Mohbad, agreed to, to the child, even if the child was not his, then that is a legal ground. So the point is that when Mohbad was alive, do you have a concrete evidence that Mohbad consented to that child? Do you have a concrete evidence from that? So if you have a concrete evidence that Mohbad actually accepted that child when he was alive, that's a different case entirely. But if you don't have a proof that Mohbad, when he was alive, actually accepted that child, I don't know how you can debate that. I don't really know how you can debate that. And that is why they are asking this young lady to go have a DNA. And having a DNA is not a crime. Doing a DNA is not a suicide. It's not on a suicide mission. The father of this child, the grandfather can contest the paternity of a child. So just like Paparino said, it now depends on the court to either grant that or not to grant it. They have the right. And you coming on platforms and deceiving people is very, very irrational. And it's very debilitating, if I can use that word. Nobody is questioning the paternity of the child because actually, just like Mr. Aristocrat said, as long as the court hasn't given a verdict yet, we cannot actually say that the child is not Mohbad's. We can't say that because we don't have a proof. And the proof is DNA, and we don't have that at hand. And if we go around to say that the child is not Mohbad's, it's not, and I think we are doing ourselves injustice because it hasn't been proven yet. Until the court have a stamp on it, then we can go ahead to say that. So Top Movie, you need to be mindful of the kind of things that you come to platforms to say because you are deceiving people. Thank you.
All right. So, you hear me? Is it network problem? Hello, guys. Hello.
I can hear you, Paparino.
Yes. So that is it. I don't know, like why this guy does this. He's just trying to prove something that is just like not feasible. I said, no, don't worry, you don't need him. Just forget about the movie. I mean, sometimes he don't just have anything to talk about. If he has something good, a good argument, or there's a good update, I don't want to discuss. I mean, we can have that conversation with him, but not on business grounds. Like you just hanging around, just trying to by every means to see that everybody is rubbish. There's nothing new that he knows, or there's nothing that he knows about legal procedures that anyone doesn't know here, or that anybody doesn't know here. We all know this thing, okay? There's nothing about the legal procedure, so nobody should threaten anybody about the legal procedure. It's very simple. Everybody knows that there is no judicial precedence on a grandfather asking for DNA in Nigeria. There is no case like this Mohbad case before, okay? So people should be educated. Let nobody say that the man they cannot be. Before, their argument was this, that the man cannot ask, that he doesn't have the right to ask. If you remember all through last year, through this year, until we debunk that. Sometimes, what pains me, the reason why we get mad at our legal team is that we will do this so much great work to defend this case, because I believe that the country, okay, that is the court, or maybe the legislatures and the government also look at the position of the people, okay? When the people are strongly, like calling for something, which they think is the right thing, right? Government most times look into such situations and then tends to adopt it, as a way of life in that particular state or place. Everybody believes that there should be no hindrance, there should be nothing, okay? If nothing is hidden, no law should be against requesting for a DNA test for his grandchild, all right? So, and the people see that this is the right path. But very few minorities, because of their act of criminality, they want to cover their shame, their criminal act. They continue to mislead the public and continue to see how they can deceive everybody using some legal grounds of, some procedures that cannot even feasibly be attained, right? To create the order of the day. So it is impossible or it is inappropriate for anybody to be going around saying that the father doesn't have any right, or it will not even be granted. However they want to put it, before they say it doesn't have any right, later they say it doesn't have the legal ground. What legal ground they're talking about? Okay, there is no judicial precedence. Judicial precedence would have been a very good legal ground that you can, you can stand on, right? But every other legal ground, as long as the man can ask, right? Then we cannot tell.
Paparino, wait. Paparino,
Yeah.
Can you bring a case whereby a grandfather asked for DNA and it was granted? Can you bring that case?
Who is speaking? Is it Abati?
Yeah, can you bring a case like that? Where
No, Abati. See what we
grandfather
are
asked
saying here.
for DNA and it was
See,
granted?
I've been entertaining him since, okay? In Nigeria, so far, there has been no issues yet. It's a new case. Everywhere in the world, there used to be new cases. No country law is perfect. When a new case arises, right, the judge apply a lot of discretion, apply a lot of consideration, and then preside over the case after looking at it, okay, from her legal knowledge, and look into the best interests and look into the best interest of the people. If it's a child, they'll look into the best interest of the child. If it's a marriage, they'll look into the best interest of the marriage. If it's a new case, and it will be established. If there is no law, if there was a law to bind that effect, for example, if there is any statutory law that was effective in place, lawyers are just going to quote it that, okay, for example, like now, burying of a child or burying of a person, section 48, okay, made it clear already that no father or no mother, nobody shall bury anybody, okay, in a situation whereby the death is suspicious and the cause of death has not been established, that nobody should bury anybody. So we don't even need judicial precedent of that. We already have a law, a legislation that condemn anybody burying a dead body whose cause of death hasn't been established, right? Now, when it comes to this DNA, on the DNA case specific, we don't have any such law that address a grandfather in the Nigerian history. That's why I was very mad. Why did Mohbad, why did Wunmi resort into negotiation? And why did Mohbad too? Why did they accept negotiating with Wunmi? I expected Wunmi to fight so hard to say that never, we can never negotiate to do this. We must prove to Mohbad that he must learn his lesson, that never should any father in Nigeria, any grandfather in Nigeria ask for DNA. By defeating the man in court, had Wunmi continue to court and defeat Baba in court, it would have been put in record for the future generation that let no grandfather wake up any day and begin to request for the DNA of their grandchild.
But you know there are some cases like that in court that is still ongoing till today.
That is what I'm saying. If it is in court,
if you do your research, there are some cases like that up to today. It's still in court.
There is no current pending DNA case in court. To
don't worry. Next time, maybe next time I come here, I will
check for DNA. Yeah, if it's DNA case, there is
don't worry. Next time I come here, I will bring that out.
You can never find it anywhere in the world, anywhere in Nigeria.
Fine. But there is one. I'm just telling you, there is one that is still on the grandfather is asking for DNA, and it is still in court up to now. And people know their time. No DNA, no barrier. So
you can never find it. Not even up to 2 years. You cannot find any case. You cannot find any DNA case that is pending more than 2 years in Nigeria. You can't even find it. Talk less of even 5 years. You can't even find 2 years.
No, it was the father of Davido that compelled Davido to do DNA. Don't say he was the one that asked for it. Is Davido dead?
The father of Davido.
But don't worry, whenever next time when I come here.
I don't have issues now. I mean, we talk with evidence. The last time that we talk about this, I think there was one guy called TikTok, lawyer of TikTok or TikTok lawyer, and then we spoke, and we all both agree. That it's a new case that nobody can say whether or not it can be granted. It can be granted. Nobody can say so.
It is not a new case. Me, it is not a new case. I know what I'm saying.
Is there a judgment on the case we are talking about?
There's no judgment until now.
So it's new now.
So it's still a case it's new now.
It's not established yet.
If there was no judgment, you can't use it as precedent. It's not established.
Sorry. I don't know that is where
there are plenty matter in court until they decide on it fully.
So this one has not been decided on yet. Why?
Exactly.
So
what we don't want to be hearing, we don't want anybody to be saying that it cannot be granted, it cannot ask. Come on now, based on who are you? Based on what? You know?
But anyways, but I understand the negotiating part. Like, okay, no DNA, no barrier doesn't make sense anymore. Let this kid get over and everybody move to their house. So the guy was like, okay, let me do the DNA. Let my husband be buried so that I can continue with my life. I think that is more reasonable. Rather holding harder for no reasonable reasons.
You see, let's say something, right? No, I know it's a different negotiation, all right? We are just the ones saying that no barrier. That is not the reason why they negotiated, all right? It is not a gentleman negotiation. We may file a preliminary objection. A preliminary objection is a motion that is filed by one of the parties involved in the proceeding, okay, to the court against the other party, requesting the court to throw out the application of the other party, that the court should check what ground, what qualification, what legal local standing does that person have to make such demand, okay? Wunmi wrote such. It was when the court looked into Wunmi's preliminary objection, and the court denied it, that, the man has the right to bring this case before the court. And then Wunmi resort into negotiation because she knew she's going to lose the case. And that's why I was angry about it, and I believe that they are negotiating.
You said she's going to lose the case.
No, you don't understand. Let's say, for example,
Wait, can you come again? You say.
Yeah, let's say me and you were arguing, okay, and you told me that I cannot ask for the DNA of your child, all right? And then I said, I am the grandfather, I will ask, all right? And then I went to the court to ask for the DNA, all right? And then the court summoned you, that is writ of summon, okay, which made you to present yourself. That is to, to answer to whatever Paparino bring against you and your baby. When you came, all right, you and your lawyer, you filed a preliminary objection. That is a procedure which is used to challenge what right Paparino have to even come and make this request before the court. All right. So when you fight that injunction, the court threw that away. It was after the court threw that away, then Wunmi resorted into negotiation with Mohbad, with their team. You see? And that was where I was mad. That the moment that the court had threw away Wunmi's preliminary objection, nobody should negotiate with her. They should take that case to the High Court and let the court decide on it so that the public can win. Right now, we are losing as a public. The family is gaining. What would have been better for us is that if Mohbad was denied, let me say Wunmi defeated Mohbad in court, it would have been on record. So we public, that would have been a gain for us. We would have known our position next time. We will not jump into what doesn't concern us.
If the case now goes for like 10 years, does it make sense to you?
At least let us go for 1 year. Let us see. After one, they can negotiate. They can always negotiate out of court. Always. Sure, you understand? They can always.
So what if both parties did not agree up to more than 1 year in court? You can't just decide and say,
if they turn back and forth and the case is delayed, okay, then they can say because of the delay, then now they want to go and negotiate behind the. But what is stopping them? Let them try first. Let's see. Maybe in the first year, maybe the next year in the court will pass judgment. Let them fight. I want to see so that their reasons by now would have gone and be reading their different reasons for educational purpose, for the public, for proserity's sake. Let something be established.
Anyways, if not drag you, Kukuma no court case. If you go 10 years, 20 years, 50 years, nothing they go. So nobody wants to.
It's not about dragging. You see, where the public will lose is this. Tomorrow you have a case like this. If this matter is determined, it becomes something that others in future will be using, for example, and say you don't need to go to court because the case was decided and the court said the grandfather has right or the father that don't have rights.
Yeah, I understand.
That is the benefit to the public. That is the benefit to the public. You understand what I mean? It's not.
I understand you.
If they like, they drag it, but the end of it is the public will benefit by understanding that when you demand for things like this, it is right or it is wrong. That is the benefit. It's not about the time. It's something that will be used forever now. Like,
no, like
look
in their own case, like the family boha is just too much. So in their own case, all the other parties like, see, I cannot be staying in court fighting back and forth with all these things. So let me just move ahead, do the settlement and go. So that does not necessarily mean that something like that, something similar to that will not occur in the future. And they will
but you see, this case has come to the public already. The fact that this case was already in the public.
Paparino, because the case comes into public. Paparino, wait now. Because the case comes into public doesn't mean that a similar case is not in the court. And doesn't mean that it can't change the law. It does not necessarily mean that their own case should be the major one. Because everybody knows about it, fine.
This is one of the reasons why in Nigeria, criminal persecution or public matters never sees the light of the day because people in between will withdraw. And it is body. For example, someone came to steal something and you call police to arrest the person. Police took the person and say, this is a theft matter, it's a criminal matter, we take it to magistrate. When they ask you to come and testify, you refuse to go. At the end of the day, they threw away the case. You are not doing justice to the system. Because what it means is nobody will be used as a scapegoat or that this thing will not be in archive for precedents. It is to save future. Bridges are built so that people that are coming behind can use it. It is not for you alone, it is for others.
Yeah,
so let us look at that. And that is why it is not all matters go to court. It is the one that needs to be tracked out. Then the court will look at it and say, okay, this case, we must finish it so that we will set a good precedent. You just said that Davido's father had demanded for DNA. Davido's father He's a grandfather.
No, I was not the one that said that. It was this Queen's Trail.
Okay,
It's true. Go to Dele Mahmoud's page. She did.
Wait.
Dele Mahmoud, she did. Yeah, she did the DNA.
I'm not arguing about that fact. This is the fact I'm arguing about. Is that does a grandfather is a grandfather regarded to demand for this and get it? If someone demands for it and the person gets it, but it is not a precedence of the court that says you have the right to get it. For example, I have the right to tell Abati to say, Abati, open your camera. I want to see you. And Abati have the right to say, no, you cannot see it. We will now say, okay, let's go to someone that will judge it. And the person now say, Abati, as long as this other person that is demanding for it opened his or her own, you too must open. That is a standard. But until that is determined, there will always be that forth and back. So it is good for the system to say, so that in future, grandfather will not go through that stress to say, I must go to court. Because there is a precedent that say, I demand for it. So the person is demanding for it will not say, I want to challenge it. They will tell you, you are wasting your time. Because there has been a court ruling that has substantiated the right of the grandfather to demand for it. So you, instead of going to court to waste the time of court, you go straight to that precedent and quote it, and it will be done. So there won't be any form of argument. But as long as it is not done, it remains a matter that must be determined.